Calling criminal action 19-71055, USA versus Alejandro Toledo Manrique. Counsel, please state your appearances for the record.
Joseph Rosanello, appearing specially for the defendant, Mr. Manrique, who is present.
Good morning.
Elisa Altazina, Christopher Smith, and Rebecca Hasiski for the government, Your Honor. Good morning.
Good morning. We're here today for a detention hearing on the government's motion for detention. As you know, the Bail Reform Act is not applicable to extradition proceedings, and nor is any other federal statute. The standards that's developed for detention is under federal common law, in which the presumption in an extradition proceeding is to detain the defendant so that the United States can fulfill its treaty obligations. Bail is possible, of course, but the burden is on the extraditee to prove that he is not a danger to the community or risk of flight, and that there are other special circumstances that may warrant release. Having said that, I'm going to proceed procedurally in the normal way that we do with detention hearings. We've done that already with having the defendant be interviewed by pretrial services and having the parties in the court be provided with a bail report. And now I'm going to proceed by proffer in the way that we normally do. Have both sides received the bail report?
Yes, Your Honor.
Yes, Your Honor.
Okay. It's the government's motion. Please proceed.
The government agrees with the court's summary. The Bail Reform Act does not apply because this is not a criminal matter. The case law does allow, as Your Honor just described, that the court can make a finding of risk of flight and that the absence of special circumstances would warrant his detention pending the resolution of the extradition proceedings. The government submits that Mr. Toledo presents a significant risk of flight and that there are no special circumstances present in this case. As the pretrial services report reflects, Mr. Toledo has no ties to the United States beyond his wife and daughter, and we have no information present in the report relating to the daughter. Significantly, he rents his residence in the Northern District of California. He has some sources of income based on work that's not specifically tied to the Bay Area, and he has no other ties to the United States. Mr. Toledo has access to presumably significant amounts of money as detailed in the extradition request, and also based on information that we have, he had a significant amount of cash in his house at the time he was arrested, and there's a large amount of money, over $1 million, which is unaccounted for at this time. Mr. Toledo has a history of extensive foreign travel. As recently as 2017, the pretrial services report reflects travel in 2015-2016. His Peruvian passport, which has just expired, does in fact reflect travel going through 2017. And he has a number of ties outside of the United States. He has ties to Peru, where he has a number of family members, and he has political connections as a result of his being the former president of Peru.
Well, the ties to Peru are the problem. If you don't care if he flees to Peru.
Correct. But those ties in Peru may facilitate his travel to other countries, and most significantly may facilitate his travel to a country that does not have an extradition treaty to Peru. Notably, Israel is one such country, and he does have connections to Israel. His wife is a citizen of Israel and potentially also of another country, of Belgium. I'm not 100% sure of that. I'd have to clarify. He does, as a result of this request, he has known about this request. It's not coming out of the blue to him, but he does have a strong incentive to flee nevertheless. He has clearly not returned to Peru. He has attempted to renew his passport prior to its expiration as recently of June of 2019, indicating his desire to travel by needing a passport. And as a result of all these factors, in addition to what's set out in the pretrial services report, we submit to the court that he does present a significant risk of flight. Now, if we shift to look at the special circumstances.
Before we move to that, but I do want to hear about that, I understand from the pretrial services report that when the FBI searched his residence following his arrest, they found $40,000 in cash in his suitcase.
That is my understanding, yes, Your Honor. I don't have any documentation of that yet, but that is what I learned from speaking with one of the agents.
Okay.
based on statements that Mr. Toledo has made to other authorities over the years, he was earning pension money, royalties from his books amounting to significant amounts of money as well. I can't say where that cash came from specifically at this time.
It's more that if there's a large chunk of cash in a suitcase, that suggests perhaps a contingency plan to go somewhere.
That could be an interpretation, yes, Your Honor.
Okay.
But again, I don't have any more detail at this time, but I will attempt to learn more about how it was found and exactly where it was. So with respect to special circumstances, that is unique to extradition cases, and therefore that's not presented in the pretrial services report because that's not a factor that would specifically be considered under the Bail Reform Act. But as we set forth in our memo, which I appreciate was filed yesterday afternoon, and the court may not have had a chance to look at it yet, nor Mr. Russinello, but the factors that I would anticipate that Mr. Toledo may raise have been found not to be special circumstances in a very analogous case in Florida. So, for example, his age of 74 years old, his health, his former position of being the president of Peru, living openly in our community while knowing that there was a warrant out for him, none of those have been deemed special circumstances by courts in the past. The government is not aware of any special circumstance in this case. It is, of course, his burden to present the evidence in this regard, and at this juncture, the government submits that there are none. And based on all the factors that have been set forth in the pretrial services report, which go towards risk of flight, the government doesn't believe they can be mitigated in any way, given the number of risk factors here and the absence of special circumstances. The government submits that he should be detained, as is the presumption in these cases under case law and as the statute contemplates, until the resolution of the extradition proceedings.
Thank you. Mr. Russinello.
Thank you very much, Your Honor, for the opportunity to make this presentation to you. As counsel has indicated, we have not seen whatever memorandum was filed yesterday, but it really is irrelevant, quite frankly, to the argument that I would make to you. I think that while we hear a little bit about who this person is, I think we learned from our experiences that in making any determination of what a person is likely to do, or the prospects, in this case, of flight or posing a significant risk, it's obviously it's the character of the person. It's that moral risk factor that's paramount. Whether or not Mr. Toledo has lived in the area for some period of time and so on is of some significance. But if you look at who he is and how deeply those ties of who he is merge with this district, I think you'll see that he spent, quite frankly, during his adult life, as much time in Northern California as he spent in Peru. He came to San Francisco for the first time as a soccer player on scholarship to USF, and he earned his education there in his degree in 1969 as a result of that. After getting that degree, he went to Stanford. He went to Stanford for 6 years in Palo Alto, where he graduated with a PhD, and has over maybe the last 25 years, he spent at least half of that time in San Francisco, in the Bay Area, and the rest of it back in Peru or on the road, basically hawking his book. I have a copy of it here, The Shared Society, which is a product of his work at Stanford as a senior fellow between 2012 and 2015. This is not something that was just sort of a comic book. This is something that was the product of his deep involvement in the economic activities of Peru in particular and South America in general, and his attempt through the political process, which he began getting involved in 1994, and through the time that he served as president of Peru in 2006, trying to better the condition of his people and his country. And I think that the record will show, I mean, it would demonstrate that it's the commitment that he made to his people, it's the commitment that he made to his constituency, as it were, people who are interested in the betterment of the society in South America, that when he came back to San Francisco, into the Bay Area, in 2016, it was specifically for the purpose of, again, rejoining Stanford as a senior fellow to complete a second work on the same area, a book that has not yet been published. And that a lot of the travel that we hear about is not travel for nefarious purposes, but basically in promotion and in a quest of further information about those subjects that are so dear to him. So the fact that he's a traveled person and the fact that he has spent time in and out of the Bay Area is of significance because it demonstrates that his commitment throughout his life has been in the course of the sort of improving conditions in Peru and improving the understanding throughout the world of how things are doing there. When he was president in Peru, the economy in Peru significantly improved. In 2005, I think the increase was 5.6% GDP. In 2006, it was 8%, rather remarkable. The imprimatur for his book comes from people like Bill Clinton and others who would say what a remarkable turnaround he performed there. But when you think about what it took for him as an indigenous person, an Indian ancestry, in Peru, a country that, like so many in South America, was gripped in the throes of authoritarian rule. In the case of Peru, the Fujimoras. What he had to endure in terms of personal threats to him and to his family in order to attain the position of president, and how he stood by that in spite of all of the threats to him. You get some measure of why this gentleman is not just a person, but an extraordinary person who is deserving of more than consideration of whether or not he's just a set of numbers.
Let me just say that I agree with that. He's certainly a very accomplished individual.
And I think it says a lot for perhaps why we're here in terms of why he would be the subject of this kind of persistent effort. I mean, remember, I think the complaint itself says that this is a process that started in about February 19th of 2017, which it answers the question of whether or not he's a fugitive, because he was here in 2016. Resuming his studies at Stanford long before there was any effort to sort of initiate any criminal investigation.
He was here openly. He was here legally. He was lecturing at Stanford. He was out in the open, not hiding from anybody.
Thank you. And I would say that in addition to the question of his character and the links to the Bay Area, which I think we've demonstrated pretty conclusively here. One of the things that's most remarkable, and I think the court can take this into account in considering whether or not let's say the exercise, this extradition exercise, is likely to be productive and result in an extradition, is to look at whether or not there's a particular flaw even in the process. Is there something about what's brought us here that we can look to that suggests that there has been either an attempt by the Peruvian government to not act with full disclosure, or perhaps some attempt to corrupt the system itself? Each treaty that the United States has with each country is different, and each one needs to be examined scrupulously with a strict constructionist approach. The treaty between Peru and the United States specifically requires that there be a charging document, that there be a charge that's issued by the Peruvian government. What we have in this case is we have an investigative magistrate. Now, I'm not suggesting that that's of the same level of deportment as Your Honor. I mean, I don't think it is. I think it's more like in the European systems where an investigative magistrate is that. He's basically almost like a one-man grand jury. But an investigative magistrate in this case is the one who authorized the provisional arrest warrant. And we're not saying that he doesn't have the authority to do that under Peruvian law. He may well. But for purposes of elevating that investigation to the level of a charged event, under Peruvian law, sections of, I think of their own laws, 354 and 355, require that there actually be something issued by a court of general jurisdiction, which was not done in this case. And because the treaty itself requires that there be such a document as the predicate for the extradition, it may be that this challenge on procedural grounds, not just on the substantive grounds, is well-founded. Mr. Toledo, through counsel in Peru, has been attempting at that level of the investigative magistrate to get more information, to get discovery that specifically addresses the credibility of the main complainants in this process, Maimon and Barada. And they have been rebuked at that level, primarily because the argument, this is an investigation. This is an ongoing investigation. It's not a case in court, and therefore, your request for discovery is premature. That pretext sort of cuts both ways. It may shield you from having to provide information to those lawyers about what's really gone on with these accusing persons. But by the same token, it debilitates you in your ability to sort of fashion an extraditable offense on the basis of what conclusions you may have reached. So it would be a shame if, because Mr. Toledo obviously thinks that the only place that he's going to get due process is courts of the United States, that the prejudice against him, as a person of Indian extraction, as well as because of his sort of hostility to the Fujimura regime, would deny him the ability to seek any justice or exact any justice in Peru. This is where he wants to fight the battle. And in doing that, I mean, there's a strong compulsion, obviously, for him to stay here and to attest the viability of these accusations in our courts. So I think that as the pre-trial services report indicates, it is possible to fashion some mechanism for ensuring that he's able to confer with his counsel throughout what's likely to be an extended and difficult process, and at the same time ensure for this court that he will be here. And it goes without saying that obviously we're here because exceptions can be made to the general prohibition against release. And we're not trying to set any precedent here at all. This is a very unique case with a very unique defendant or extraditee. And I think the court would be well within its jurisdiction and sound discretion to fashion some mechanism that would ensure that he could assist counsel and at the same time remain out of custody.
One issue that concerns me, as I raised with the government, is that after Mr. Toledo was arrested, the FBI searched his home, and they apparently found $40,000 in cash in a suitcase. It's possible that's where that guy keeps his cash. It's also possible he's got some contingency planning. He could toss some clothes in the suitcase and, make a run for it. Can you please speak to what significance there might be in that?
I think I could actually put on a witness who would be able to say that's what they were living on. I mean, that money was kept by his wife, whose assets are separate from his, because in any attempt anywhere to sort of express that there is property someplace has resulted in the government running in and seizing it. I mean, that's why the report, as it comes out, if the court sees it, a report of all of his assets, all of the different properties that he's owned around the world, residences and so on, have all been seized. His pension has been taken. A pension that he earned as president, even that has been seized. Not even O.J. Simpson's pension was available for confiscation. But under Peruvian law, apparently this was. So I would submit to you that if, as a proffer, that if Eliane Akarp were sworn to testify, she is his wife, she would say that was her money for purposes of being able to sort of continue their living expense and to pay whatever attorney's fees arose from time to time that they were required to satisfy.
Okay, thank you.
May I respond, Your Honor, to
Yes,
comments?
can you please specifically address the issue of the charging document?
The charging document, in terms of the issue raised by Mr. Rosanello, is whether or not it's validly issued, and that is a determination that the United States defers to the requesting authority. The government's position and understanding is that it was in fact lawfully issued, and that is something that will be borne out during the litigation in this case, presumably the nature of the charges and any other challenge to them. Contrary to what Mr. Rosanello is suggesting, Mr. Toledo will not have an opportunity to, for example, go to trial on these charges. This is an extradition request solely. It's not an adjudication of the underlying charges.
A probable cause determination.
So if he wants to seek justice here, he will obviously to a limited extent to determine whether or not the request submitted to the United States by Peru satisfies the requirements of our treaty with them. If I can comment a few things, I'll go with the last issue that Mr. Rosanello just raised with respect to the property. So the pretrial services report mentions that Ms. Toledo reported that she and her husband own a home in Peru that is paid in full, and estimated current market value is $1 million. So first of all, the government believes that in fact they have additional properties based on the request itself, details additional properties beyond just one home. And this report is completely contrary to what was just proffered to the court, in that they do still own property, both of them, free and clear, which perhaps has not been seized by the Peruvian government. The government submits that he seems to have access to a significant amount of money. With respect to the issue of whether or not he's a fugitive because he was in the United States when the arrest warrant was issued, he is nevertheless still considered legally a fugitive. He is in the United States. He has consciously chosen not to return to Peru to face the charges, and in fact he has not traveled internationally since the issuance of that arrest warrant. So notwithstanding all his prior travel, he's purposely not traveled now. The government argues that he hasn't traveled because he has known there's a warrant for him. He does not want to return to Peru. He has every incentive to leave America and go elsewhere where he is not going to be forced to return to Peru. Mr. Rosanello has largely argued that Mr. Toledo's good character, his history and the work he did for Peru are reasons why he should grant bail, and the government is not going to contest or comment on what he has said. The point is that none of those factors are special circumstances. He has not met his burden as required under the case law to prove to this court that there are special circumstances warranting his release on bail. Every other defendant in a case, Mr. Toledo is considered a fugitive, not a defendant in a criminal case here. Every person who is detained has access to their lawyer. That simply cannot be the basis for being released pending the extradition hearing. Given the presumption that he be detained and the risk of flight that he does present and the lack of special circumstances, again, the government submits that he should be detained.
May I respond briefly?
Yes.
On the property in Peru. Because I became aware of this, I asked counsel in Washington, who's been working on this since 2017, to find out what the status of that was, and he informed me that it has been seized. Now, I think there's a Peruvian prosecutor in the courtroom, if I'm not mistaken. He would know. Put him under oath, and we'll find out. As to the travel. Knowing that Interpol may well have acted on the investigative magistrate's issuance of the provisional arrest warrant in 2017, Mr. Toledo would have been a fool to have tried to travel to countries where he was to make a speech or to attend a conference or whatever, to be detained and arrested and have to face the authorities in a country which didn't respect his rights nearly as religiously as we did. And as to the proceeding itself, I don't know if, and I'm going to call you Ms. Becker because that's the only way I'm going to remember who you are, whether the prosecutor remembers the cases of Suarez Mason or of William Quinn, who were two extradition cases, one involving Argentina, one involving England. It's easy to say these are very abbreviated processes, but it was the discovery in those cases that really not caused fits, but that took an incredible amount of time to work through. And in this case, the idea and notion that on the basis of what this Peruvian government says is what Maiman and Barada have told it, given how they have been totally discredited as a substantive presentation would demonstrate, is to suggest that this hope and expectation that there would be full due process accorded to him in the American courts would be a bit of a charade. And I don't think that's true. I think he has a right to and will get a full hearing on all of these accusations. And so I think that we're working here in the category of the exception. Are there circumstances that have been demonstrated to suggest that he will attend the hearings and proceedings, and that he will, with whatever conditions are imposed by the court, scrupulously respect those to ensure that he does nothing to jeopardize his ability to defend himself on the substantive issues?
Okay. Thank you both. I'm ordering the defendant detained. He is the former president of Peru. In extradition proceedings, there is a presumption of detention so that the United States can fulfill its treaty obligations. Because of who this particular defendant is, these treaty obligations assume an outsized importance. If the defendant were to flee, this would be a diplomatically significant failure of the United States to live up to its obligations to Peru under the treaty. So this defendant is not just an alleged common criminal, but a political figure who it's important diplomatically for us to show that we've complied with our treaty obligations to Peru. In addition, I believe that Mr. Toledo is a flight risk. When the FBI searched his home following his arrest, they found $40,000 in cash in his suitcase. I understand the defense's proffer that this was the cash that belonged to his wife and it was for their living expenses. However, it does mean that he was mobile. It does mean that he could potentially have taken that suitcase and gone to travel. He is a well-traveled individual who has been to many countries around the world and has a lot of connections, and I think that there is a flight risk here. In addition, the defendant has not shown that there are any special circumstances that will warrant release. So based on all of the foregoing, I order the defendant to be detained, and I'll ask the government to prepare a draft order for my review. Thank you. I would also like to set a date for a case management conference.
Before doing that, Your Honor, I ask the court to entertain a motion on my part to withdraw as per the counsel for Mr. Toledo. I've had this discussion briefly with the federal defender about this action, so he's fully aware of what's likely to occur.
And so, Mr. Kalar, would you be substituting in?
Yes, Your Honor. Good morning, Your Honor. Stephen Kalar from the Federal Defender's Office. Your Honor, I've had an opportunity to speak with Mr. Russinello, who was kind enough to alert me to this contingency. I've also met with Mr. Toledo, and my office would be delighted to take the case. I understand the government may have views as far as Mr. Toledo's assets. I'm invoking the 2014 Memorandum of Understanding. I'm handing a copy to the court and a copy to Government Counsel. As the court may know, I downloaded this from the court's webpage this morning. In 2014, there was a Memorandum of Understanding for just this situation. And the government agreed to provide discovery relating to financial assets before there's a determination of agency and for my appointment. And I'm confident Government Counsel will comply with that memorandum. I would propose the following. I would propose we return before Your Honor on the 24th for status. I would ask that my colleague, Graham Archer, be noticed as lead counsel on the case.
I'm not here on the 24th. How about the 26th? The Friday?
That would be fine, Your Honor. And Your Honor,
excuse me, would you expect me to be here on that date? Because
sorry, I'm going to grant your motion to withdraw. Mr. Russinello, you're withdrawn. Mr. Kalar, I am going to appoint your office. As to the question of whether the defendant should be required to put up money to pay for the public defender's office, I'm not going to rule on that today. I'm just being handed the MOU. I'm going to defer that decision until the next time we see each other.
I appreciate that, Your Honor. I think that my colleague, Mr. Archer, would like an opportunity to meet with Mr. Toledo. Of course, I anticipate the court will be looking for a financial declaration. We'll be pleased to provide that. We will be looking for discovery from the government before we complete that declaration. I happen to be a member of the negotiations on that MOU in 2014. There was an understanding from the court that in cases such as this, it could take some time for the defense to review the discovery and submit the financial declaration. And I'm sure the court and government counsel will accommodate us on that request. I also think that Mr. Archer would like to review this court's decision today on detention. I was in court and I heard and respect Your Honor's decision, but of course that is subject to review. And Mr. Archer and I will meet with Mr. Toledo and discuss various options on that detention decision. So I would ask for provisional appointment until the 26th. Mr. Archer and I will be meeting with Mr. Toledo in the interim, and we will be meeting and conferring with government counsel as well.
Okay. The provisional appointment is approved. I'm going to set this matter for a status hearing on July 26th at 10:30 a.m. Do you want to just discuss the further appointment, or should we get into more substantive issues of logistics and case schedule at that time? Okay, is that acceptable to the government?
So just a status appointment of counsel and to set next dates for other discussions.
Yes, please, Your Honor.
Okay.
Understood.
That's fine. We'll come back here on July 26th at 10:30 a.m. to discuss the status of appointment of counsel and to set further dates. Is there anything else either side would like me to do this morning?
Your Honor, I mean, there may be an issue because there is no discovery in this case. It's a formal request made by the country. So the material that we have is what we have. We'll provide it to Mr. Kalar, but we don't have access to anything beyond what we were given. So it's not a traditional criminal case where there's discovery of other bank records or some other access to records.
I understand that. Why don't you meet and confer with the other side about what you're able to provide, and we can take that up at the next hearing. All right. Thank you both. The defendants remain into custody.